Good afternoon, everyone, and welcome to our Ashford's webinar on the Renters' Rights Bill. Is it time to act now? My name's James Hemsley. I head up the Property Disputes Department at Ashford's. Just a little bit of housekeeping before we start. If everyone could just mute their microphones so we don't get any feedback, that would be great. The webinar is being recorded. If you have any questions, please put them into the chat and we'll try to cover them at the end. If we don't get time at the end to deal with them, then we'll happily follow them up directly with you, or we might produce a crib sheet if there's some interesting topics that come up. Just to start a little bit about the Property Disputes Department at Ashford's. We've grown rapidly over the last few years. We now consist of around 40 fee earners spread across 3 offices, Bristol, Exeter and Plymouth. Whilst our webinar focuses today on the changes to residential tenancies, we also undertake the full range of property disputes work, including commercial landlord and tenant, insolvency and secured recoveries, telecoms, rights to light, agriculture and the like. And we also work across a whole range of sectors, including investment, development, finance and public sector. My colleagues today, Emma Hindon and Lucy Carey, are going to take us through some of the fundamental changes to the law around residential tenancies, and in particular the significant impact the Renters' Rights Act, when it comes into force, is going to have on the residential rental market. So I'm going to hand over to Emma now. Emma.
Thank you, James, for the introduction. Welcome, everyone. Like James said, this is the first in a series of events that our property disputes team will be hosting, considering the Renters' Rights Bill. So today we're going to be providing an overview of the legislation and highlighting the steps that agents and landlords should look to be taking now, with particular focus on serving Section 21 notices. So I should say at the outset that we're talking today about the bill in its current form. So the bill is in the course of consultation, and therefore there are likely to be amendments to the proposal as currently drafted and the final law. So for that reason, the contents of this webinar won't be intended to be legal advice, although you are, of course, always welcome to get in touch if you need assistance with any specific situations. So, starting with a brief background to the Renters' Rights Bill, the bill was first introduced to Parliament in May 2023 as the Renters' Reform Bill. Labour then reintroduced it as the Renters' Rights Bill in September 2024 with some significant changes. As of this year, consideration of the bill has now moved to the House of Lords. It's in what's known as the committee stage, and so there are a couple more stages that it needs to pass through before it's enacted. These include a report stage, another reading in the House of Lords, and then we essentially reach the stage where it's passed back and forth between the House of Commons and the House of Lords until its final version is reached. It's not known at the moment when the bill will pass into legislation. However, there is political will on both sides of the House to implement it, and it's thought it could come into force as early as spring this year. So the headline of the Renters' Rights Bill, which I'm sure you will have all heard, is the ending of no-fault evictions, or more commonly known as Section 21 notices. Currently, the law allows landlords to evict their tenants at the end of a fixed term without specifying a reason, utilising the procedure under Section 21 of the Housing Act. The Renters' Reform Bill aims to abolish those Section 21 no-fault evictions, which it hopes will provide tenants with enhanced security of tenure. So landlords will only be able to terminate their tenancies by satisfying one of the grounds that are set out in Schedule 2 of the Housing Act and serving what we commonly know as a Section 8 notice. As it's currently drafted, the bill proposes amendments to those existing grounds, in addition to introducing several new grounds for possession, and we will talk through those grounds and the amendments in this webinar. The law will have retrospective effect, meaning that at the date of implementation, landlords will no longer be able to serve a Section 21 notice on tenants, irrespective of when the tenancy was granted, unless one of the statutory transitional provisions apply. So we're going to have a quick look at those provisions. So to take advantage of the transitional provisions as currently drafted, landlords must serve a Section 21 notice before the Act comes into force, and then issue proceedings before the earliest of one of the following dates. So where you've served a notice relying on 2 months, it will be 6 months from the date of service of that notice. Where more than 2 months' notice has been provided, i.e. where you've got a contractual tenancy that might require more than 2 months' notice, then it will be 4 months from the expiry date of that notice. or 3 months from the commencement date of the new law. So once the earliest of those dates have passed, it will no longer be possible to rely on the Section 21 notice for possession if proceedings have not already been issued by the court. On the face of it, these timelines are not problematic as they reflect the current deadlines for issuing proceedings. But as the Renters' Rights Bill could be implemented as early as April this year, the deadline imposed at C could be as early as July 2025, and this will then effectively override the other deadlines if they expire after this date. So therefore, any landlord who wishes to rely on a Section 21 notice to recover possession proceedings should be considering acting now in order to avoid or limit their ability to do so once the Renters' Rights Bill comes in. Landlords also need to bear in mind that delays could arise if any other steps are required prior to service of the Section 21 notice. For example, we see problems all the time with gas safety certificates, obtaining an EPC, service of the How to Rent Guide, or if a deposit needs to be repaid because it hasn't been secured properly in accordance with the deposit regulations. Although the legislation is currently in its draft form, no significant amendments are anticipated, and such landlords should be considering their position now as a matter of urgency and seek specialist advice if they need to know how to proceed. So moving on to the impact on an existing Section 8 notice. If a Section 8 notice has been served and proceedings have been issued before the legislation comes into force, those proceedings will be allowed to continue. This means that proceedings which rely on an old ground or an old notice period will continue on the same grounds, provided it was issued before the bill was enacted. However, if you have a situation where you've got a Section 8 notice which was served before the legislation came in, but proceedings haven't yet been issued, you're going to need to rely on these transitional provisions. And it's going to be the same as before, so based on the earliest of the following dates. So the period of 12 months from the date of service of your notice, or the period of 3 months beginning with the commencement of the Act. So if proceedings haven't been issued by the earliest of these dates, you're not going to be able to rely on the original Section 8 notice, and you'll need to serve a new notice based on the amended grounds for possession, and that might mean that you've now got an increased notice period. As mentioned before, with the bill anticipated to come into force in spring this year, landlords might only have until July to issue proceedings based on their previous Section 8 notices. So if you're wishing to terminate assured short-hold tenancies, and you should be considering whether there's any advantage to using a current Section 8 notice or perhaps serving both a Section 21 and a Section 8 notice now, particularly as many of the notice periods for the existing grounds are being extended. So I'm now going to pass over to Lucy to discuss the most significant changes within the bill.
Thank you, Emma. So as Emma has just kindly introduced, I will be discussing some of the significant changes we're expecting to see once the bill is passed into legislation. As we currently understand, on the date of commencement of the bill, the current assured short-hold tenancies are expected to become assured tenancies, which are referred to in the bill as Section 4A assured tenancies. These tenancies will all be periodic with a maximum rent period of 1 month. With the removal of the fixed term, tenants will be able to serve notice on their landlords from day one of the tenancy, provided that they give at least 2 months' notice. The requirement for written notice has also been extended or expected to be extended to allow tenants to give notice by email or text message as opposed to requiring written notice on paper. As Emma will go on to discuss in more detail shortly, notice periods for landlords serving notices on tenants will be dependent on Section 8 grounds that they intend to rely on, and so the time frame for being able to serve the notice and also the notice period itself will differ accordingly. I think it's understandable that the removal of the fixed term will provide less security for landlords and consequently uncertainty due to the likely result in a higher turnover of tenants. Although, as we currently understand, the fixed terms are expected to be removed, there is also currently a proposed amendment to be debated as to whether they should consider amending the bill to allow for fixed term tenancies on agreement between both parties. However, as I say, it is to be debated, and I'm unsure how successful this is likely to be. Sorry, Emma. Thank you. And on the subject of the proposed amendments, there's also further proposed amendments that are currently to be debated in respect of student accommodation. So one of these essentially is in order to exempt the student accommodation to the current exemption for the periodic tenancies to be enforced by the bill. So essentially, as long as all students in the accommodation meet the student accommodation exemption, the student test, sorry, apologies, as long as all students in the accommodation, all tenants in the accommodation meet the student test, then they will be essentially open to potentially being exempt from the fixed term tenancies. This would allow students to have a fixed term tenancy that aligns with the academic year, providing landlords more security and minimising risk for the tenants to be leaving mid-year. Along with the potential exemption for student accommodation, a further proposed amendment seeks to regulate the timing of student tenancies, potentially preventing students from signing tenancy agreements before the 1st of March in the year in which the tenancy is intended to take effect. This is an attempt to essentially prevent students from signing tenancies too early and being pressured into agreements without having more time for consideration. Sorry. So in addition to the amendments to the new tenancy system generally, landlords can also expect new compliance obligations to be implemented following the introduction of the bill. The first new compliance obligation is the private rented sector landlord database, or the PRS database. This will essentially be a register of private landlords in England, in addition to the already existing registers for HMOs and selective licensing. At present, it's not known what will be stored on the database aside from names and addresses of landlords and their properties. However, at present, it's going to be compulsory for all landlords to register themselves and each of their individual properties on the database. Failure to do so by landlords could result in a fine of up to £40,000, and repeated breaches for landlords could be subject to a rent repayment order of up to 2 years. Whilst it's likely that private landlords will find this new requirement onerous in some aspects, it may also be beneficial for self-managing landlords managing their own properties. There is currently no certainty as to when the database will come into effect. However, it's looking likely that it will take effect at the same time the bill is introduced. It's unlikely that it will take effect when the bill is introduced. Apologies. The second new compliance obligation is the PRS Landlord Ombudsman. The guidance on this currently claims that it will provide quick, fair, impartial, and binding resolution for tenant complaints about their landlords. It's worth noting that this will be a way for tenants to complain about their landlords and will not consider landlord complaints about tenants. It's expected to be compulsory for all landlords to be a part of the Ombudsman. At present, it's also looking as though the PRS Landlord Ombudsman will likely be the same as the Housing Ombudsman, but for social housing, which is already in place. However, this has raised some questions as to how they intend to deal with the issue of capacity, considering there are already ongoing delays, and with the new obligations for landlords, it's expected that there may be an influx of complaints the Ombudsman will be expected to deal with. Finally, the third compliance obligation for private landlords will be the PRS Decent Home Standard. As some of you may already be aware, the Decent Home Standard already applies to social housing and allows the local authority to take enforcement action where the standard is not met. Introducing the Decent Home Standard to the private rented sector will look to set a clear minimum health and safety requirement for private rented properties in an attempt to crack down on homes that currently do not meet the standard, which, according to English Housing Survey in 2022 to 2023, about 21% currently of private rented homes do not meet the Decent Home Standard. The bill would also grant new powers to local authorities, allowing them to issue penalties to landlords that fail to prevent their house being subject to these serious hazards. And this is in an attempt to essentially incentivise landlords to make their properties remain safe and decent. As with the other compliance obligations discussed, it's unsure when these are likely to take effect and how it's going to be assessed, as it's unlikely the local authorities will have the resource to inspect themselves each individual property that is registered. However, there is discussion about it already forming part of the PRS database, which was discussed, the first compliance obligation that was discussed. So in addition to the removal of the fixed term and the implementation of the new compliance obligations, the bill, as currently drafted, will be making significant changes to tenancies as a whole. Prior to tenancies being entered into, they will be looking to end rental bidding by requiring property listings to state a proposed rent and not allowing landlords to accept offers over that proposed rent. There is also going to be an attempt to combat discrimination in the private rented sector. Landlords or their agent must not prevent someone who has children or might need to claim benefits from inquiring or viewing a property or entering into a tenancy. The current employment consideration as to affordability is obviously still allowed to be considered. Local authorities will also have the power to take action for breaches and to impose financial penalties if this is seen to be the case. Further, tenancies must not contain the right for landlords to terminate the tenancy other than by using the Section 8 procedure, which Emma will be touching on later on the webinar. As mentioned in the previous slide, the Decent Home Standard will be applying to the private rented sector, as well as Awaab's Law. Awaab's Law is currently an implied term in all social housing tenancy agreements that require social landlords to investigate and remedy safety hazards such as damp and mould in the properties within strict time limits. The bill will also look to enforce a maximum rent deposit of 5 weeks. Whether more can be accepted is uncertain due to the interpretation, and whether it would be classed as an unlawful payment under the Tenants' Fees Act is to be established, but you definitely can't be demanding more than 5 weeks' rent. Finally, landlords will be restricted when increasing rent. This will only be able to take place once a year by serving a Section 13 notice, giving at least 2 months' notice and increasing the rent up to market rent. Market rent is defined as the price that would be achieved for the property as a newly advertised let. Tenants will be able to go to the first-tier tribunal to challenge increases, during which time the increase in rent will be paused and landlords will be unable to backdate the increase. The first-tier tribunal will also be prevented from recommending a rent higher than what the landlord has asked for. This is likely to encourage more tenants to challenge their rent increases, as it essentially is a win-win due to the inability to backdate the increase or for the tribunal to increase it further. So I'm now going to be passing back over to Emma, who's going to be talking through the new and amended Section 8 grounds.
Thank you, Lucy. So yes, I have the lovely task of talking through all of the amendments to the ground and the new grounds. So Schedule 2 of the Housing Act provides several grounds which, if met, permit a landlord to obtain an order for possession. These grounds are split into mandatory grounds and discretionary grounds. So a mandatory ground is one where if a landlord seeks possession using this ground, the court must make an order for possession if it's satisfied that the landlord has met the conditions for that ground. Rather than a discretionary ground is one where if the landlord relies on it, the court must be satisfied that it's proven that it's met the ground and it is also reasonable to make an order for possession based on the facts. So following the implementation of the Renters' Rights Bill, a landlord will need to establish a ground for possession if they want to obtain possession of their property. In order to enable landlords to obtain possession of their properties, the bill will extend the existing grounds and also incorporate new mandatory grounds for possession. Unfortunately, we don't have time to discuss all of the amendments today, so I've put a summary of the key proposed amendments to the existing ground on the slides, and we will just talk through those ones. So the first one, Ground 1, this is an amendment to a ground which already exists under the Housing Act. In its current form, Ground 1 allows landlords to take possession where they've given the tenant written notice of their ability to recover possession on the basis of the ground. At some point before the tenancy was granted, they occupied the property as their own or principal home, and they require that property back to use as their principal home for themselves, their spouse, or their civil partner. So the main amendment to this ground is that the definition of family member will be expanded. So this will now include parents, grandparents, siblings, children or grandchildren, and also those of a spouse or a partner. The legislation also confirms that a relationship of the half-blood is to be treated as a relationship of the whole blood. So that will also include half-siblings, etc. There'll also be no longer a requirement that the landlord occupied the property prior to the commencement of the tenancy. However, the ground won't be available during the first 12 months of the tenancy, and the landlord won't be able to market or re-let the property for 12 months after the expiry of the notice. So that the notice period is going to be increased from 2 months to 4 months. So it's widened in some respects in terms of the application of family member, but obviously we've now got an extended notice period and they won't be able to re-let the property for 12 months. Moving on, we've now got Ground 6. This is the existing redevelopment ground and is to be used where the landlord wishes to demolish or substantially redevelop the property and works cannot be done with a tenant in occupation. There are substantial amendments proposed to this ground, and the amendments differ depending on the type of landlord and the type of tenancy. I don't intend to discuss these all in detail today. However, broadly speaking, the intention to redevelop will no longer satisfy this ground, and an additional criteria has been inserted so that the landlord must meet this criteria to prove that they meet the ground. The notice period has also been increased from 2 months to 4 months, and the ground won't be available during the first 6 months of the tenancy. This is obviously to prevent landlords from relying on the ground at the outset. A relevant social landlord who intends to carry out redevelopment work will need to provide alternative accommodation that meets specific criteria which is set out, and that accommodation will need to be available when the order for possession takes effect. There are some discrepancies at the moment amongst the various drafts of this bill as to whether a landlord needs to have acquired its interest in the property before the tenancy was granted to be able to rely on the ground. It seems that the intention behind it is that this restriction will only apply for specific types of agricultural lettings and not residential lettings, but it's currently unclear. So we hope this is going to be cleared up at the point the bill is enacted. So watch this space for developments on this point. And then ground 7, this is the existing mandatory ASB ground. The key amendment to this is that the notice period will be reduced from 1 month for fixed term tenancies and 4 weeks for periodic tenancies, so that landlords can now issue a claim immediately. The standard requirement that Lucy discussed about properties being registered on the new database will also not apply to this ground. But the requirement to meet one of the 5 antisocial behaviour conditions will remain, and you won't be able to meet the ground if an appeal against the conviction, order or finding is pending or successful. And then finally, for the mandatory grounds, we've got ground 8, which is the existing mandatory rent arrears ground. So this one, the notice period is going to be increased from 2 weeks to 4 weeks, and then the time period for outstanding rent is also going to be increased. So for tenancies where rent is paid weekly, it's going to be increased to 13 weeks. Formerly it was 8 weeks. And for rent paid monthly, it's going to be increased to 3 months, and it was formerly 2 months. Like before, the arrears will be required at time of service of the notice and also at the date of the possession hearing. So if a tenant can reduce their arrears to below those thresholds, a possession order won't be made. The bill also provides that if the rent arrears are as a result of universal credit payment delays, then there can't be an eviction under this ground. This is simply enacting case law, which is already applied by the district judges in the courts. So we don't anticipate there being any issues with this. Additional amendments are also proposed to grounds 2, 4, 7 and 7B as shown on the slides, but due to time constraints today, I won't be touching on these. But if anyone's got any concerns or would like any further information on these grounds, please don't hesitate to contact us separately after the webinar. So there's also several additional new mandatory grounds which have been proposed, which I will just bring up on the next slide. So the first one is ground 1A. So this is a ground that the landlord will be able to rely on if they want to sell the property. This will only be applicable after the first year of the tenancy has elapsed. It will require 4 months notice, and it won't be available to be used for registered providers of social housing, so it'll be private landlords only. There will be, however, a social housing rent to buy ground, which is ground 1B. This will be 4 months notice, and this will obviously apply where the landlord is a registered provider of social housing and the property is currently rented under a rent to buy agreement. Moving on, the next one is ground 4A, which is the student accommodation mandatory ground. Lucy's already discussed the student test which landlords will be required to meet to satisfy this ground, but essentially this ground should be used when the property is an HMO let to full-time students and possession is required at the end of the academic year. It won't apply if even one of those tenants is a part-time student, so regard will need to be made to those who might be PhD students studying part-time. The notice must also expire within the window of the 1st of June to the 30th of September each year. So whilst there's only 4 months notice, practically speaking, landlords will probably need to look to arrange service of their notice around March to April of each year if they want time to have a void period, perhaps before another tenant moves in, to get it up to that lettable standard which Lucy talked about, and arrange for gas safety certificates, electrical certificates and EPCs to be carried out. There's also several employment grounds which are being added. These are 5B, 5C and 5D. Essentially, they've got three different ones depending on the type of employment. So 5B is an occupation by person who meets employment requirements. So this is for a private registered provider of social housing who holds the property for use by a tenant that meets requirements connected with their employment. And that property is then required for that purpose. And the current tenant doesn't fulfill that criteria anymore. We've also got ground 5C, which is the end of employment by the landlord. This was previously ground 16 in the current Act, and it's been expanded. So should be used in situations where the dwelling was let as a result of the tenant's employment, and that employment has now come to an end, or if the tenancy wasn't meant to last the duration of the employment and the dwelling is now required by a new employee who does require that dwelling. And then finally, we've got 5D, which is for private registered providers of social housing, and that includes an employment requirement in the tenancy agreement that the tenant no longer fills. So, for example, if you've got a key worker that's no longer fulfilling that role, and all of those grounds will require 2 months' notice. And then two more to talk through today. We've got ground 5H, which is commonly known as the stepping stone accommodation ground. This will be a mandatory ground that social landlords or charities can use where they let the property to a tenant that meets their eligibility criteria. So it's to do with properties that are let at an affordable rent to help them access private rented sector and or transition to living independently. If the tenant no longer meets that eligibility criteria or the limited period that the tenancy has been granted has come to an end, then they'll be able to rely on this ground. It is 2 months' notice, and obviously the landlord needs to be a registered provider of social housing or a charity to rely on it. And then finally, for today, ground 6A is the enforcement action ground. This is where a landlord is subject to enforcement action by the local authority or a banning order, and they need to regain possession to become compliant with that order. There'll be 4 months' notice for use of that ground. There are also some specific mandatory grounds which will be introduced, which I don't have time to go into today. They relate to end of superior lease, a possession where superior lease ends, possession by superior landlord. There's also some more grounds which relate to social housing providers for occupation of supported accommodation, dwelling house occupied as supported accommodation, or if a tenancy is granted for a homelessness duty. Once again, if you'd like any further information as to these additional grounds, please don't hesitate to contact us separately after this webinar and we can put something in place for you. There are also some proposed amendments to the discretionary grounds for possession and also an additional discretionary ground. So in terms of the amendments to the existing discretionary grounds, we've got ground 10 and 11, which are both the rent arrears grounds. Ground 10 being one where there's some rent arrears, but you don't meet the threshold for the mandatory ground. And ground 11 being the ground for persistent delay in paying rent. Both of these, the notice period is going to be increased from 2 weeks to 4 weeks. They then got ground 14, which is the discretionary antisocial behaviour ground. So that's where the tenant or anyone living or visiting the property has been guilty of causing a nuisance, annoyance, or convicted of using the premises for illegal or immoral purposes. Whilst the notice requirements will remain unchanged, the bill will introduce further matters that the court must specifically consider when deciding whether to make an order for possession under this ground. The court will need to determine whether the person against the possession order is sought has engaged with attempts by the landlord to resolve the behaviour, and also take into consideration the impact of the antisocial behaviour on other tenants in the property or those who might share facilities or accommodation with the perpetrator. In our experience, these are already factors that the courts take into account when determining whether a possession order should be granted. But obviously now these will be confirmed in statute rather than applied at the discretion of the courts. And then finally, there's one additional discretionary ground that's been proposed, and that is ground 18, which is supported accommodation. So this is for where a tenancy has been granted for supported accommodation and the tenant isn't engaging with the support that's being offered. This is going to have 4 weeks notice period. So that was obviously a whistle-stop tour through all of those grounds. Of course, in order to satisfy them, a landlord is going to be required to provide proof. This is particularly important for the discretionary grounds where a court will need to be satisfied that the ground has been made out and it's reasonable to make a possession order. So landlords should be making sure they hold copies of all documents. These would include evidence of rent arrears, if relying on the rent arrears ground, copies of correspondence with the tenant. Obviously, this will apply for all of the grounds. Copies of correspondence with a letting agent if the landlord's wanting to use ground 1A, sale of the property. Copies of correspondence with a building or surveyor if they're wanting to use the redevelopment ground 6. And if the landlord is a company, that all necessary company resolutions have been passed. It's also worth having evidence that planning and building consents have been obtained or will be obtained within a short time of the application. So what now, Lucy?
Great, thank you for that, Emma. So I think some of the points that, on our next slide, there we go. So we've covered some of these points already throughout the webinar, but due to the uncertainty as to when the bill will pass into legislation, landlords should be taking steps now to consider the impact and effect of the expected changes. As Emma previously discussed, landlords should be considering their position in respect to serving Section 21 and Section 8 notices now and seeking legal advice on how to proceed. So just some practical tips really for landlords considering the changes at this present time before it comes into effect. We would recommend landlords start getting on top of record keeping and just kind of looking into rent statements, contact records with tenants, tenant complaints, and just kind of getting on top of those records just to then this will then assist them once the bill is passed with serving Section 8 notice if this is required. Landlords should also start reviewing their internal processes in order to consider future compliance with the Decent Home Standards. This could vary from how they manage their tenant complaints, how they respond to reports of damage or disrepair from tenants, and ensuring that these can be managed within a reasonable period of time. And finally, landlords may want to also consider reviewing their tenancy agreements in line with the new legislation, both now and also in 6 months' time after the enactment of the bill, to account for any additional amendments that may be required. So that being said, I think we have some questions to move on to. We've got some pre-sent in questions from some people that are on the webinar today. So we're just going to work through those, I think, if that's everything. So we've got the first question we've got is, will Section 21 be replaced with something similar? So at the moment, not that we're aware of, the purpose of the bill is to remove Section 21 and replace it with the extended grounds of Section 8. Although at present, I think there is actually a debate as to whether there's a proposed amendment to be debated, essentially to suggest whether Section 21 notices could be used for smaller landlords with less than 5 properties, although the likelihood of this actually taking effect, considering the purpose of the bill, seems unlikely. So Emma, anything else you'd like to say on that one?
Yeah, I don't think so. I mean, I think whilst it was a nice proposal to be made, I think the whole purpose of the bill was to remove Section 21 notices. So I think it's going to take a strong government to go back on that and change the position. Also, I think 5 properties is quite a large amount. So for a lot of landlords, and therefore the argument I think that was made was that landlords who perhaps wouldn't have access to money to pursue multiple legal claims would be able to serve Section 21 notice, but it seems slim pickings for me. I think that there might have been an ulterior motive for the person that put forward that proposed amendment. I wonder if they might have 4 properties that they that they would like to serve a notice for. But yeah, what's the next question, Lucy?
So the next question we've got is, with the demise of ASTs, is there an acceptable alternative such as a license agreement?
I think this is it's a really good question, but ultimately it falls back on the same position that we have now. Obviously, there are situations in where a license can be granted, but they are quite narrow. And where you've got a situation where ultimately you have a tenancy, you should be granting a tenancy. The courts are very used to applying the law in relation to the differences between a license and a tenancy, and they'll be able to see through what is known as a sham agreement. So where you've got a tenancy tenancy that is ultimately called a license. Obviously, you can call the agreement what you like, but it's going to come down to, on the face of it, how that agreement operates in practice. So if you've got a property where you are granting exclusive possession for a term and you are accepting rent that is above the threshold, then ultimately you're going to be granting a tenancy whether you would like to grant a license. So ultimately the advice is going to be that you should continue to grant a tenancy, but obviously just making regard to the current provisions that we've got, the grounds that we've got, making sure that you keep a copy of all records that you need, that you might be able to rely on any ground. It's going to be a bit of a turbulent time for landlords, and a lot of these grounds, we're going to have to see how they operate in practice, how the county courts are actually approaching the law. Obviously, the government is the one that actually legislates, but the courts are the ones that actually implement that law and interpret it. So it could be that actually what we have on paper is interpreted slightly differently in the courts. We would hope that there's a bit more leniency towards landlords, considering the fact that we will be removing the option of them to terminate their tenancies without any good reason, but that still remains to be seen. Hopefully, though, there are enough grounds that one of them you will be able to satisfy if you need to, but that will remain to be seen once the law comes in, I think.
Yeah, I agree. Thank you. So what is the consequence for other HMO tenants if one should give notice? So if tenants are jointly and severally liable, unfortunately, this essentially would end the tenancy, and we would be looking to agree a new tenancy with the existing tenants. Obviously, with the no fixed term tenancies, this may cause some issues for landlords. But I mean, if we're talking an HMO with student lets, we would hope that the exemption would come into force with the bill, so that may potentially assist with that issue. But yeah, unfortunately, the HMO, as long as the tenants are jointly and severally liable, then this would end the tenancy as a whole, and a new tenancy would need to be agreed. Anything else you'd like to say on that one, Emma?
Yeah, I mean, I think it's going to be, I said it's going to be a turbulent time, but specifically in relation to student lets. Obviously, now there's going to be, well, at least as currently drafted, there won't be a fixed term applied. So landlords are no longer going to have a guaranteed rent for a guaranteed period, and could be in a situation where tenants, particularly in relation to student accommodation, are serving notices after sort of 9 months of the academic year, rather than staying for the whole year. So it could be that we're in a situation where the student accommodation market is just completely decimated. Alternatively, I think we'll find that the market rent for student lets is probably going to increase, where we find landlords increasing the rent for those lets in anticipation of the fact that they're no longer going to have a guaranteed income stream for 12 months. So they're going to look to ways to recover that over 9 months rather than 12 months, for example. So a lot of this, again, remains to be unseen, and it's sad that we can't give you anything more definitive at this stage, but I wouldn't be surprised if there does have to, if there essentially is going to be more legislation surrounding this, and actually once the courts start to implement it, they realise that different provision is required for student accommodation. So there's still a chance that perhaps fixed term might be agreed for student lets, and it remains to be seen whether they agree to that.
I think it seems reasonable, but yeah, we will see. So our final question that we've got is, what alternatives are there for international students who would normally pay rent for the full term in advance? So with this one, I mean, I don't know whether you want to take it, but unfortunately, I don't think that really is one. Obviously, we touched on the maximum amount of rent in advance that you're going to be able to take, and obviously it's still open for interpretation when it comes down to whether it could still be accepted, or whether that is limited to it can't be demanded. I think from what I've read, there seems to be differing interpretations of that, and whether it would come under a prohibited payment or not. So yeah, I think, again, as Emma said, it really is still open for interpretation on that point, but unfortunately at the moment I can't see that there is any alternative, unfortunately.
No, I mean, I have seen there's a spiel of speech on LinkedIn from people with various commentary about whether you could still accept it if an international student kind of voluntarily agreed to give you an additional amount. I think it's a situation where landlords are going to need to tread carefully because A, are they going to be able to satisfy the ground that actually they haven't demanded this and it was given to them voluntarily, especially where if you've got an international student, you may have an individual where English is not their first language, and therefore there could be situations where emails are misread or perhaps there's some confusion. Also treading carefully where you've got people outside of the jurisdiction who might not be aware of what the current law is in England and therefore operating differently. Certainly we've seen before in relation to Section 21 and protection of deposits where, if a landlord were to accept more deposit than the cap, that doesn't, even if it was volunteered by the tenant, that isn't an excuse for taking a prohibited payment. So I certainly would act with some caution on applying the defence that they just accept it willingly as opposed to demanding it. But it's something that, again, is likely to come out in the later months and years as this legislation is enacted and situations are brought to force in front of the courts. But in terms of letting to international students, again, I think it's going to be a market that's decimated. Landlords, again, are going to need to tread carefully, especially with the new discrimination rules coming in. And it wouldn't surprise me if we later get a prohibition about refusing to let to international students. So if you've got a situation where you're perhaps reluctant to let to an international student because you can no longer take huge amounts of rent up front, I think you need to be very careful in the way that you consider refusing to let that property to that individual, because it may later be that we're in a situation where that becomes another prohibition. But other than that, unfortunately, as it currently stands, there isn't really any alternative, which I appreciate is not the news that landlords will want. But I think, is that all the questions we've received?
It is. That is all the questions that we've got. Any others, I'm sure we can take away, and we've got some upcoming roundtable events that we can always apply those to. So
Yes, I've just seen a question from someone saying, can we distribute the slides? Yes, I'm sure our marketing team will be able to arrange for the slides to be distributed. Like James said at the beginning, it has also been recorded. So hopefully a recording will be available to you all. But other than that, all it leaves me to say is thank you so much for joining us today and taking the time to listen to us for an hour speaking about the Renters' Rights Bill. Like James and Lucy have said, we've got more events coming up. So please do keep in touch with us, and you're always welcome to contact us via our contact details for further questions. But yes, thank you for joining.
Thank you both. Hopefully everyone found that interesting and informative. And I think there's obviously going to be some more detail coming out and in due course. We do have a dedicated Renters' Rights Hub on our website, ashfords.co.uk, where you'll see a recording of this webinar and some articles we've already produced. If you go onto our website and click on Insights and then Spotlights, you'll find your way to our hub. We're also going to be running some further webinars, hosting roundtable discussions and producing some further articles throughout the year as the Act gets implemented, as well as it's once it finds its way through the courts and the judges get their claws into it. We'll be able to find out a bit more and share some of our practical experiences with you. So just leaves me to thank Emma and Lucy again and wish you all a good day. Thank you very much.
thank you very much.
Thanks, everyone. Bye.